Every day in the USA, people find themselves in court.
One case. Joseph Samuel, 23 CR 1866. That you?
Yes, sir.
And you were charged with state jail felony, burglary of a building? Uh-oh, we got some priors here. So, 2-8. Wow. Okay. So you got 3 prior felony convictions here: burglary of habitation in 2008, burglary of habitation in 2010. Thereafter, those were final. It said he committed the offense of assault on a security officer, a felony, and that was, and you were convicted in 2014. So even though this is a state jail felony, it will be punished if you're found guilty as though it were a second-degree felony. You're looking at 20 years in prison. Do you understand what you're looking at?
Yes, sir.
Okay. Go ahead.
You want you admonished him when he was in court.
I don't remember.
Oh,
But you remember better than I. But whatever you say, Langston, you got me supporting you. Go ahead.
no. You had explained that to him, and the offer was 12 years TDCJ. Mr. Samuels, I gave a police report. We went through all of that. You can tell the judge, what was your response? What did you say?
Okay. You're not eligible for probation. You know that. If you're found guilty, it's who is McKinley Nails?
Brother of the deceased was property owner.
I see where this is going.
Okay.
Well, what can you tell me about this? I'm just curious. The defendant have, I guess you're going to complain, he's got a proprietary interest in the property somehow. Is he his brother dies, is he the beneficiary of the property? I mean, is there like a will or something that gave him the property?
Not, he haven't told me anything about it.
Oh, okay.
No, he has not.
Well, I mean, there's seems to be a lot of confidence here with the defense, but why is that? I mean, is there something we should know about? It says the effective consent of McKinley Nails, the owner. Who is McKinley Nails?
He is the brother of the deceased property I was calling.
Wait. McKinley is deceased.
No, he's the brother of the deceased.
He's the brother. Who are you?
I'm that's the perpetrator of this called.
No. How are you related to the deceased?
I'm not. McKinley Nails is related to the deceased who the property owner.
Oh, okay. I get it. Oh, okay, I'm sorry. I thought you were related
Oh, no, sir.
to the deceased who owned the property. Oh, okay. Well, there's something I'm missing here. Well, what the heck is going on? I mean, you were caught at the scene, right?
Yes, sir, but I didn't brother, they said I brother was good as I was in the middle of the garden.
Well, it done, okay. Yeah, I know Mr. Adams is going to talk to you about what it takes. Burglary under the law, you don't have to enter anything. They say breaking and entering, you don't have to, all you got to do is try to get in some property. And if you try, then that's all it takes for burglary. You don't have to succeed. They can catch you trying to get in and you're still outside the building, but if you're trying to get in and they catch you, you got it. Your stuff. That's the way the law is. All right. And you're not eligible for probation. Okay. We're going to set this for trial. He wants trial. That's what we do here. So it'll be set for trial. What is the bond on this case? What is it? Huh? 8,000.
You feel plead true to the enhancement on the probation. Okay. That's 220. Yeah. Yeah. So it's a third degree enhanced to a second. Judge, do you want to do a drug test?
I was over there getting.
Me personally? No. But I would give one to you.
I'll pass.
I'm-
That's not what I was
does he have
asking.
any- Does he have any drug convictions?
Um,
Yeah, no. Looking, he's got burglaries. Sir, just a second.
One second, I'm Judge.
Just a second, hold on. Probation?
Sir.
Yeah, we're gonna need some help here. Before you leave, just have a seat over here and we're gonna do a quick test on you, make sure you're okay. Good roast. Good Colombian roast.
Which one did you go with, Judge?
I don't know, I just randomly choose.
It's not the Judge Stevens roast, is it?
No. Oh, no. Jake the Taurus roast. 22-40978, and I recognize this man. Trevor Dustin Burge. You've been in here in the past. I couldn't have said your name, but I remember faces real good. You were here with Mr. Crenshaw, your attorney, good man. And you chose well. There is a motion to and this is what's disappointing. We put you on probation in 23, and you were able to get this from a third degree felony where you're looking at 10 years in prison to 1 year, a class A misdemeanor. And you should have been happy with that. And now we're seeing you back here because there's a motion to revoke probation that was filed about a week ago. And it alleges that you, among other things, committed the offense of assault of bodily injury on a family member on or about March 13th, 2025. And you were apparently in arrears on your fees. And those are two allegations being used in this motion to revoke probation. And, you know, you don't have to be found guilty beyond a reasonable doubt of this. It just is a preponderance of the evidence standard. And that's all it takes to revoke probation. And you are looking at up to 1 year in the county jail. Class A misdemeanor, right, everybody? It's not enhanced anyway.
That's correct, Judge.
All right. So this was, you pleaded to this assault, family violence, choking, and which is what's in the indictment. And the motion to revoke says, or about September 14th, 2023, that you were placed on probation for that. And then here in March 13th, about 3 weeks ago, 2 or 3 weeks ago, that you committed assault.
That's being indicted as a felony, Judge.
I'm looking for who's the,
Same victim.
oh, the same victim?
Yes, sir.
You weren't supposed to have any contact with that person as well, right?
That may have been modified because of the marital relationship.
Oh, it's a spouse?
Yes, sir.
Spouse was.
And this,
Rarely- Yeah, I would do it probably for that because I would have been convinced at the beginning here that all of this was in the past, but courts, the nightmare all judges have are putting victims in harm's way
yes, sir.
after it's been pointed out that they were victimized, and you pleaded guilty to something. And I presume under oath, when you pleaded guilty, you were being honest to me that you committed assault. And that was not supposed to resurrect its head again. And here is an allegation saying that you've assaulted this person again. What am I supposed to do now?
Judge, we're asking for a bond,
Mm.
please be set on the MTRP.
What else can you do to convince me? Because he's not going to have any contact with this person.
And that's no issue.
It's
my
It
advice
wasn't supposed to be an
to him
issue.
to initiate divorce proceedings and to not have anything to do with her again. And likely we'll have to go back to family court and see what they're going to do.
Well, you're going to have this one.
Trial
You're
situation.
going to have to deal with this with me too. This motion. And you're looking at up to a year in jail. Maybe that's not a big deal, but let me just say, it is my practice that somebody who's on probation for an offense and then they commit a similar offense, they're going to be the likelihood, depending on what the evidence is. I mean, you got a story, maybe you're completely not guilty. But if you were, the consequences would be severe for this type of offense. So you're looking up to a year in county jail. If I revoke you, and we're going to get this done pretty quickly.
State's ready to proceed on it on any date, Judge. I could have a
You're not
witness
ready to do that
appears.
here for a hearing on the revocation, right?
Absolutely not.
Okay, we're going to postpone it and we're going to set it for a hearing and can you be ready in 6 or 8 weeks? What do you think?
I mean, I haven't seen any evidence on it. I mean,
What we're going to do is set it for an announcement like in 4 weeks and let me know where you are on it. Okay. Now,
Sure.
let's get back to this.
Yes, sir.
What can you do to convince me that you're not going to harm this person again? What can you do?
I would rather him not say anything.
No, I'm looking at him, but you can speak for him because
And-
you're the guy that I'm focused on. You've got my attention, which you don't want.
He's gonna move out, if he hasn't already, and.
Have you moved out already? Is that yes? You have to speak out.
He's been underneath the magistrate's protective order since the offense
I
day.
know it. I know. You're out of there.
Yes,
Go ahead.
and he won't have any contact with her until.
Where are you gonna live?
I'm in my travel trailer again.
Where's that located?
In Baltimore.
I mean, it's not around this lady.
No, sir.
You're going to have a GPS device.
Judge,
Hold on. I'm just,
yes, sir.
while I'm
He can have
thinking,
an ankle monitor.
you're going to have a monitor. So I know where you are. And if there's ever a problem that, he was around me, I saw him or something like that, we'll know where you are.
Judge,
Unless-
I'm sorry, but I know you're making decisions about bond conditions and there's 2 important matters that I need you to consider.
Yeah, go ahead.
Number one is that he was given a misdemeanor bond on what is a felony offense. He was released on a $4,000 bond, which has the normal conditions about not having contact, as well as the magistrate protective order. The state's in possession of evidence that he has been contacting the victim of this offense since he's been arrested. That's in violation of the protective order as well as the bond conditions. And if we're considering what kind of bond,
In what way?
he's been trying to call her from the jail. She hasn't been taking those calls, but we have the recorded the attempts.
What's
And
that about? Why would you?
What
do
he
that?
what he has done historically in the past is pressured her into dropping charges. She was the reason why I modified these charges from the felony to a misdemeanor. And so he's just returning to his past behavior. I don't know that there are any conditions today that can be set that will guarantee that this man doesn't continue the same kind of conduct he's done.
What do you have to say?
I would say that I emailed Mr. Ham on Friday about this. I've had no communication from Mr. Ham about this. It's a misdemeanor. He's on deferred. We're asking for a bond to be set. I'm not aware of any evidence of him contacting her or attempting to call her from the jail. They do have kids together. They are married. I think that now he understands that if he attempts any contact or has any contact with her in the future, that it would result in his bond being revoked and him being put back into jail.
What's his bond? What was his bond?
misdemeanor bond was set at $4,000. That is being indicted. I'm repeating again, that's being indicted as a felony. And so that $4,000 bond is inadequate.
Well, and Your Honor, it's not before the court. We're here today on a motion to set
The
bond.
motion, the motion to revoke probation.
And the
is
state,
before the court.
could have at any point,
Hold on, there's not a bond
in the
yet
past
on this
6
motion.
days.
There's not a bond set on this motion yet, right?
Correct, Judge.
Because that's an issue. Then that's the new case. So that's another thing. We're in the command in here, but he's gonna have to deal with that.
And we certainly will, Judge. If we could just please get a motion on, or a bond set on, this issue, and, he's gonna abide by all the rules that you set.
Is that right? Is that right? You're gonna abide by all the rules?
Yes, sir.
And I mean, he knows now, if he contacts her again, it's a quick
You
way,
can't undo what you did.
right back to the jail cell.
I mean, there's a motion to revoke probation that's been filed that alleges wrongdoing, and I'm always concerned about victims who rely on me for their safety when somebody's released. So I'm out there stuck. I'm the one as well, and I don't like that. And I'm going to protect victims, just like your rights. Okay, here's what I'm going to do. Your bond, what was it, 4,000?
4,000 on the misdemeanor offense
Okay,
that is.
this motion to revoke
charged.
probation is a $10,000 bond. You must have a GPS device as a condition of your bond at all times. You cannot have any contact with this lady, nor attempt to contact her. I find out you even try. I'm gonna ask the state to get me the material from the jail calls. And
I've already uploaded it to Discover this morning for defense counsel.
and I'm gonna look at that, and we may have to revisit that issue. I don't even know what you're trying to do. You know, you got in trouble, and you're going to attempt to contact the lady. You don't, period. Nor anyone on your behalf contact her. Do you understand? Do you understand?
Yes, sir.
You have to speak,
Yes, sir.
because there's going to be complete clarity here. I find out, I will whiff of smoke that you tried. We'll bring you right back here, and it'd be quick. Then your bond would be $1 million. But nobody's going to be harmed on my watch if I can prevent that. Everybody separates. Then we work the rules of law out in a civilized manner, not on our own side deals, which is contrary to the rules. You have to follow the rules. We're going to have a hearing on this motion to revoke probation. And
Can we get a definitive date today, Judge?
when can y'all be around?
I have no ability to give an accurate prediction of that.
I'm gonna give you
nothing.
I'm going to give you an announcement in 2 weeks. Okay. Give you 2 weeks.
Just
check
at
it.
4 weeks, Judge. I mean,
Did I say 4? All right, 4 weeks. All right. That's what I said. I'm going to stand by that.
Yes.
Announcement, but let me know which direction we're going to head.
And he may have different counsel about that.
Where are you going to live if you can post a bond?
In my travel trailer,
Where is that compared to where this lady lives?
about 25, 30 minutes away from my house.
Oh, okay.
Yeah, it's
Is it in a
in the
different county?
Beaumont area. She lives in Nederland.
Yeah. And the GPS device, you have to have that immediately when you're released. Immediate. I don't want a gap of not knowing where you are when you.
Yeah, once he's released, Judge, I'll make contact with Johnny and get him an ankle monitor put on.
And we're gonna, and I'll keep an eye on it. They'll send me updates. Just, I don't find out about it, your head will swim. You lose your bond, you lose your freedom. We'll sit this out until we have a hearing, and that will be added into the equation of what this court is going to do, which would be in your worst interest. Do you understand? Everybody knows what the rules are. And what you've done is you've done something that sticks out unusual. People know when you stick your hand on the stove, it burns you, which is what happened when you were placed on probation. Now you got a motion to silence. Well, that was fun. Let me stick my hand on the stove again. No, who does that? We all know this isn't the right way to do things. But you pay consequences, you get punished for it. And we're going to protect folks. And you got to deal with this civilized, especially somebody that is your spouse
Yes, sir.
that you claim you love. It's completely foreign to that word. If you don't love her, just respect her. Don't harm her. Okay? Do you understand?
Yes, sir.
You gotta
Yes,
have
sir.
some feedback. So I know I can trust you. Shame on you next time. Shame on me on this one. Shame on you next time. We're before me, okay? Do the right thing. It's not that hard. We all have to do the right thing. Okay, 4 weeks. 4 weeks.
Yes, sir.
Okay, get a reset.
Just a GPS.
GPS.
Yes, sir. It's 2 copies.
You're going to sign this one, Mr. Burge, on one of the conditions of probation, which will be amended today for this GPS.
It's the same thing. I just did 2 copies.
You'll fill it in. So,
Thank you.
all defendants are punished for 2 things: the circumstances of the crime that they're charged with, and criminal history. And your criminal history, you have 3 prior convictions here listed: 2 burglaries of a habitation, and then an assault on a peace officer. And they are in a sequence method. That is, you committed a crime, were found guilty. Afterwards, you committed another crime, were found guilty. Afterwards, you committed this crime of burglary. So this state jail felony that would have only carried with it up to 2 years in state jail is now increased to a 2nd-degree felony punishment. So you're looking at up to 20 years in prison. And we drug tested you. You know you tested positive. You know you do. You know it. All defendants know you tested positive for tetrahydrocannabinol, marijuana, and if that wasn't enough, you've got cocaine in your system as well. So, what is this bond?
8,000.
Your bond is now $25,000. Plus, you must have a drug patch as a condition of bond because you didn't follow the bond rules in the first place. And if you're able to post a bond and get out and you test positive again, it'll be $100,000. We're going to keep doing that because those are crimes. That's a crime. You've got 3 prior convictions. You're charged with a new crime. And this testing positive, that's possession in your system of serious drugs. Cocaine is a felony. And I can give you advice all day long, but it's your choice. You know what's right. You know what's wrong. You're a grown up. When you do wrong, you pay a price for it, as I would. And that's why I try to follow the rules. Now, what were you doing about trying to get a lawyer? This ought to put you back now, make it harder.
Hopefully, start off. Try to put a retainer down, like,
Who was it you talked to? You remember?
I've been saying,
Well, are you able to afford that now that you're going to have to post a $25,000 bond? No, you need to fill out an indigent form. Has he already done it?
License is where.
Attorney.
Oh, Langston's his attorney?
Uh-huh.
Oh, you've retained Langston.
No.
I haven't paid him.
Stand by. Let me see this. I gave it back to you. Let me make sure there's an indigent. I'm sure I would have
And then
ordered you to fill one out in the first place.
from the jail. Should have the.
Yeah. Okay, you filled out one a while back. So Mr. Adams is still your attorney. And we will inform him of your status. And we're gonna set that. What was it set for?
He said trial.
Okay, we'll put it on the trial docket. And let's move it forward to that, okay? So you were in custody, sir, and we'll
All right,
tell
Richard.
your attorney. Thank you.
Good goal.
Thank you.